Good day, my name is Mark Mellor. I'm an attorney here in Riverside, California. I've got a number of business clients in Barstow that are dealing with issues of starting up their own companies, and they want to know the ins and outs of limited liability companies and corporate entities. So I thought I'd put together a quick video to give you some of the ins and outs and some of the pointers to think about when dealing with starting up a new business entity. The first thing you want to do when you open up a new business entity is you want to talk to your CPA or tax professional about what the best tax advantages are in starting up a new entity, whether that's a limited liability company or a S corporation or a C corporation. Whichever of those is best, once you talk to your tax professional and get a decision about what entity you need to form, you can come see an attorney like myself and we can form that entity for you, and at least you know on both ends of the spectrum you'll be treated well. Now, what about corporation versus LLC? Well, the first thing that they have in common is that they both have liability protection for you individually, meaning that if you're sued, they can't sue you individually for work that your company does, as long as you haven't commingled the accounts or you've signed everything as a corporate officer and not individually. Then you have corporate protection or LLC protection, and you are insulated from individual liability, meaning your house is okay, your stocks and bonds, your bank accounts personally are okay. The next thing you want to think about in terms of tax treatment is the operational ability of each. I have a number of investor clients that have LLCs. They choose the LLC form because they get better tax advantage for their real estate holdings with an LLC versus a corporate entity. With a corporation, you have two choices. You have an S corporation and a C corporation. The reason why those distinctions are important is because of the tax treatment to both, and also some of the restrictions related to both. With an S corporation, you're limited to 500 shareholders or less. You can't have corporate shareholders with an S corporation, meaning a corporation can't hold stock. In very limited circumstances, can you have a family trust or so forth, but those are very isolated incidences. With a C corporation, you can't have corporate shareholders. It really doesn't matter. The C corporation gets some additional tax incentives, but they usually are doing more volume of business. Also remember that unlike an S corporation, which is taxed like a partnership, a C corporation is taxed twice, meaning the corporation is going to be taxed on the income it receives, and then you're going to be taxed individually on the K-1 income that you receive from the corporation, hence double taxation. An S corporation is taxed like a partnership, I said, where the income comes through the corporation, it's expensed out through the corporate expenses, and then whatever's devolved to the shareholder paid taxes on the K-1. Those are some of the distinctions you want to think about. In terms of liability protection, both offer liability protection for you as an individual, but if you have some particular questions or things you want to go over, feel free to call my office and I'd be happy to talk with you about them.